Section 8 of the Charter of Rights and Freedoms protects everyone in Canada from unreasonable search and seizure. An entry into your house is presumptively unreasonable if it's done without a warrant. And there are some circumstances in which police can do it without a warrant. It's important to know those so that you can fully understand your rights. My name is Nicholas Wands, but I'm a criminal defense lawyer in Stratford, Ontario, and this is Don't Talk TV. Now, a couple of weeks ago, I did a video explaining the right that everyone has in Canada to not answer the door to their house if they don't want to. And I explained that part of the reason behind that is your right to be secure from unreasonable search and seizure under the Charter of Rights and Freedoms, Section 8. Now, I did allude to the fact that there are exceptions to those, and I want to give a brief explanation of some of those exceptions so that you can better understand your rights and assess any situation that you're in. Although, of course, I do always advise that you consult either myself or another lawyer for specific legal advice in your circumstances. Now, the Supreme Court of Canada, in a case called in Hunter and Southam, lays out the test for assessing a warrantless search. That case lays out a test with several steps. The first is that the person claiming that their charter rights have been infringed must show on a balance of probabilities that they had a reasonable expectation of privacy in the place that was searched. Now, in the case of your home or a residence, this is very easily done. It's well established in the case law that individuals have not only an expectation of privacy in their homes, they have a very high expectation of privacy in their homes. So once that first hurdle's been crossed, the onus now shifts over to the Crown Attorney, or the representative of the state. So once that's been established, the search is now presumptively unreasonable, and the state must justify it by showing on a balance of probabilities that the search was not unreasonable. And to do that, there's a three-part test. Firstly, they must show that the search was authorized by law. Secondly, that the law that authorizes the search is itself reasonable. And thirdly, that the search was conducted in a reasonable manner. So to give you an example of some laws that will authorize warrantless searches, we can look firstly at the Controlled Drugs and Substances Act and the Cannabis Act, both of which allow for police to enter residences if they have a reasonable belief that there's evidence of a crime under those statutes occurring within the residence and that they have to enter that residence in order to prevent the destruction of evidence. Under the Criminal Code, there are similar sections, such as Section 117, which allows police to enter a residence in order to search for weapons. Section 487 of the Criminal Code allows the police to enter a residence in what are called exigent circumstances, which really it's an emergency situation where police have reasonable grounds to suspect that their entry without a warrant is necessary in order to prevent imminent danger to the life or safety of an individual within that residence, or if they believe that an indictable offense is occurring, again on reasonable grounds, and that they have to enter that residence without a warrant in order to prevent the destruction of evidence. Now, on this last point, it's important that this relates to indictable offenses, which are specific offenses of great severity under the Criminal Code of Canada. An indictable offense is not a bylaw infraction or a health code violation or having too many people in your house or the police suspecting that you have too many people in your house. There's also provisions under the Mental Health Act to enter a residence to apprehend an individual. But then aside from the statutory provisions allowing warrantless entry, there's also common law. Common law rules have been established over hundreds of years that allow state officials, and specifically police or peace officers, to enter a residence. These are similar to the criminal code provisions that we've heard, and they relate to the police's duty to protect life and safety of citizens, and therefore they can enter a residence without a warrant if they reasonably believe that it's necessary to do so in order to protect the life or safety of an individual within. And furthermore, they have to believe that there's that imminent danger that I've mentioned before. So An example of this would be if they receive a 911 call and they hear someone screaming on the call or someone saying they're being attacked. The police don't have to knock on the door. They can enter that residence as soon as they arrive in order to save that person's life. Of course, if you answer your door and if you let police into your house and you let them search the house, the Crown doesn't have to prove any of this because you've consented. And I think, as you can see from these examples that I've given, that it's very specific circumstances with a relatively high threshold before police can enter. So police will certainly think twice before entering your residence, unless it's a complete emergency situation, in which case it'd be very clear, and in which case they most likely would not be knocking anyway. They would be immediately entering without even taking the time to knock in order to save someone's life. Again, as always, this video is not legal advice. Every case has its own specific facts and details that need to be weighed. Call me or call another lawyer for advice on your specific circumstances. So this has been another episode of Don't Talk TV, and remember, don't talk to the police, and certainly don't talk to them without speaking to me or another lawyer first. I hope you found this video interesting and informative, and if you have, please consider liking and sharing it.